All right, hello everyone. Sorry about that. We are here with our video. Audio is working. Great. Welcome to Uncivil Law. So we are waiting for the Supreme Court decision. Sorry for my distraction, but I'm trying to do two things at the same time. I've got audio in my ear. I'm listening to something else at the same exact time that I'm doing this. So this is going to be distracting. It's something completely unrelated to this. So trying to pay attention to two different things at the same time. So now I'm listening to audio that's unrelated to this and trying to pay attention to chat and trying to read cases. So it's awesome law done quick with a handicap. Anyways, we're gonna do this thing. We are waiting for two decisions from the U.S. Supreme Court today. We're waiting for the Trump tax returns cases, and we're waiting for the Where is Tulsa, Oklahoma case. Those are the cases we're waiting for, so we'll see. All right. We've got an opinion. It is the Oklahoma case. All right, guys, you ready for this? You ready to figure out where Tulsa is? Here we go. Where is Tulsa? The Major Crimes Act provides that within Indian country, any Indian who commits certain enumerated offenses shall be subject to the same law and penalties as other persons committing any of those offenses within the exclusive jurisdiction of the United States. Indian country refers to all land within the limits of any Indian reservation under the jurisdiction of the United States government. The petitioner was convicted by an Oklahoma state court of 3 serious offenses. He unsuccessfully argued in state post-conviction proceedings that the state lacked jurisdiction to prosecute him because he's an enrolled member of a Seminole tribe nation and his crime took place on a reservation. He seeks a new trial, which he contends he must take place in federal court. All right, so here's the holding, guys. Ready? For the purposes of the Major Crime Act, land reserved for the Creek Nation since the 19th century remains Indian country. Okay, well, for all those guys who's had half of it in Oklahoma, it was actually not in Oklahoma. I guess you won your bets. Yeah, Congress established a reservation for the Creek Nation. An 1833 treaty fixed borders for a permanent home to the whole Creek Nation of the Indians, and promised the United States would grant a patent right in fee simple, which is what we call like land when you own it. It's called fee simple. That's what happens when you own land. It's called fee simple because that's what we call it in law. To the Creek Nation of Indians for the assigned land to continue so long as they exist as a nation and continue to apply the country hereon assigned to them. The patent formally issued in 1852. Through the early treaties did not refer to the Creek lands as, because I'm a patent lawyer, does that make me an expert in this field of law? Let's go with no. Anyways, not that kind of patent. Through the early treaties did not refer to Creek lands as a reservation. Similar language and treaties from the same era have been held sufficient to create a reservation. And later acts of Congress referred to the Creek reservation, leaving no room for doubt. In addition, the 1856 treaty promised that no portion of the Creek lands would ever be embraced or included with or annexed to any territory or state. Good. And the Creeks would have unrestricted right of self-government within full jurisdiction over the enrolled tribe members of the tribe. Congress has since broken more than a few promises to the tribe. We broke a few of these treaties. Nevertheless, the Creek Reservation remains. Once a federal reservation is established, only Congress can diminish or disestablish it. Doing so requires a clear expression of intent. Oklahoma claims that Congress ended the reservation during the so-called allotment era, a period during which Congress sought to pressure many tribes to abandon their communal lifestyle and parcels to have more individualized lots. Missing from the allotment era, however, is any statute evincing anything like a present and total surrender of all the interests in the affected lands, and this court has already rejected the argument that the allotments automatically ended the reservation. So we might have given away all your land, but the reservation remains. Yeah. Oklahoma ultimately claims that historical practice and demographics are enough by themselves to prove a disestablishment. This court has consulted contemporaneous usage, customs, and practice to the extent they shed light on meaning of ambiguous statutory terms, but Oklahoma points to no ambiguous language of any of the relevant statutes that could plausibly be read as an act of session. Such extraterritorial considerations are of limited interpretive value and at least compelling from evidence. In the end, Oklahoma resorts to states' long historical practice of prosecuting Indians in state courts for serious crimes on contested lands, various statements made during the era when we gave away all the land, and the speedy and persistent movement of settlers into the area, but these supply little help with the law's meaning and much potential for mischief. In the alternative, Oklahoma contends that Congress never established a reservation, but instead created a dependent Indian community. To hold that the Creek never had a reservation would require willful blindness to the statutory language and belief that the patent of the Creek somehow made their tribal sovereignty easier to divest. So, yeah, somehow because we gave you the land, it made it easier for us to take away your rights, which is a strange conclusion, right? The Congress established a reservation, non-dependent Indian community for this Creek Nation. Even assuming that the Creek land is a reservation, Oklahoma argues that the Major Crime Act has never applied in Eastern Hack of Oklahoma. Good luck with that plan. It claims that the Oklahoma Enabling Act, which transferred all non-federal cases pending in territorial courts to the Oklahoma State Court, made the state courts the successor to the federal territorial courts, sweeping authority to try Indians for crimes committed on these reservations. That argument, however, rests on state prosecutorial practices that defy the language rather than allow us to play terms. Finally, Oklahoma warns of potential consequences that will follow a rule against it, such as unsettling an untold number of convictions and frustrating a state's ability to prosecute crimes in the future. This court is aware for the potential cost and conflict around these boundaries, but Oklahoma's tribes have proven time and again that they can work successfully as partners. I'm not sure about that, not now. And Congress remains free to supplement its statutory discretion anytime. So anytime Congress wants to come in and remove this tribal claim, Congress can always do it. So anytime Congress wants to pass a law saying the tribe is no more, Congress can feel free. Gorsuch writes the opinion in no surprise to anyone because he was obviously a swing vote, and this is a 5-4 decision, which is absolutely no surprise to anyone. So for all the people out there who said, for all the people out there who were betting the eastern half of Oklahoma was Indian tribal land, which I said, incidentally, was the most logical legal conclusion, but I was dubious that that would be held. So I guess I was right? Question mark, question mark? Because I refused to make a formal prediction, but I did say several times that well, if you follow the case law by the precedent, if you follow the case law by the precedent, this result would have to emerge. So I guess I was right. Yay. So we will definitely be covering that in more detail at some point later because we're going to be reading the whole thing and try to figure out what the heck just happened. But presumably what just happened at a minimum is I guess every criminal conviction of an Indian tribe member that's occurred in the last 100 years in state court just became poofed and went into the void and never happened because they're void ab initio because you never had subject matter jurisdiction. So that means those cases never existed. So 100 years worth of criminal cases for Indians who committed serious crimes in the eastern half of Oklahoma just basically went poof into the night and those crimes never happened and the convictions never happened and it's all gone, I guess. Super exciting. Well, that was fun. All right. Well, are we moving on to case number 2? Okay. Well, yeah, we have 1 minute left. We have 1 minute left. So we did where is Oklahoma in 9 minutes. Aren't we thrilled? Yay. So I guess I'll give myself a point on that one. I refuse to make a formal prediction, but I did say several times that if you follow the precedent through and you follow the case law through, the Congress can do it. It has to be explicit, and the language wasn't explicit enough. And so, yeah, Gorsuch being a textualist, that makes sense because you're looking to straight text, right? And the text didn't say that. So, yeah, I guess I'm right. Yay. And we'll try to figure out what the implications are of that later. Yeah. And also, of course, the implications are not just for this Oklahoma territory. So the implications are not just for half of Oklahoma. There are presumably other tribal claims, other places, including in New York, I think, where this logic would follow. So the implications for this are pretty serious. So the immediate implications are for the criminal convictions. That's the most obvious implication. The less obvious implications are for taxing authority, regulatory authority, whether or not these Indian tribal communities can put in place, bans of alcohol if they wanted, or bans of whatever else, or establish casinos and blah blah blah. So I mean, there's a lot of potential ripple-on effects. So that's what's happening. So Tulsa is now no longer in Oklahoma. Tulsa is now in Indian country. It's in the Seminole Indian tribal land. I guess. Okay, well, that's the thing that happened. So, yay, I got that one right, I guess. Yeah. Okay, we also have the Trump tax cases just came down, no surprise to anyone. So, my prediction here is that the Congress and the Southern District of New York will get the tax records. So, my prediction is that they're going to get the tax records. So, I did make a prediction on this one, but we don't actually have a link to the decision yet. The vote is 7-2, which tells me that he's going to get the tax records. And here is the link to the opinion. All right, guys, here we go. Trump versus Vance. Is this consolidated? Formally, no, I guess. Anyways, in 2019, the New York County District Attorney's Office, acting on behalf of grand jury, served a subpoena ducis tecum, which is just a subpoena for stuff, as opposed to a subpoena for a person. So subpoenas ducis tecum is a subpoena for stuff. On Maraz, USA, for the personal accounting form for the president, for financial records relating to the president and his business. The president, acting in his personal capacity, sued the district attorney and Maraz in federal district court to enjoin the enforcement of the subpoena, arguing a sitting president enjoys absolute immunity from state criminal process under Article 2 and Supremacy Clause. He might not be able to be indicted, or might not be able to be tried, but can the grand jury get these records? Yes. I don't see a problem with that. Where were we? The district court dismissed the case under abstention doctrine of Younger. Ooh, don't see that all the time, but basically it's a case that says that the federal courts should occasionally stay out of stuff. So it's a we should not hear this case. So you don't see that a lot, but yeah. And an alternative held the president was not entitled to injunctive relief. The Second Circuit rejected the district court's dismissal under Younger, but agreed with the court's denial of the injunctive relief, concluding the president's immunity did not bar enforcement of the subpoena, or rejecting the argument the United States as an amici in that state grand jury subpoena seeking the president's document must satisfy Hines' holding. Held, Article 2 and the Supremacy Clause do not categorically preclude or require a Hines standard for the issuance of a state criminal subpoena to the president. Now notice the wording very carefully here. Right? We're not talking about an indictment. We're not talking about a criminal trial. We're not talking about a criminal conviction. We're talking specifically about a criminal subpoena, right? So the implications for things beyond that point remain open. But yes, you can get the documents, which is all they really wanted, to be quite honest, right? They didn't really want to prosecute. They just wanted the documents. So they got exactly what they wanted. Anyways, in 1807, John Marshall, president of the Circuit Justice for Virginia over the trial of Aaron Burr, granted Burr's motion for subpoena ducis tecum directed to President Jefferson, and rejecting the prosecutor's argument that the president was not subject to subpoena. Marshall held the president does not stand exempt from the Sixth Amendment guarantee that the accused have a compulsory process for obtaining witness. So the Sixth Amendment allows a person to get criminal process, and that includes against the president. You know, if he has relevant evidence you need, yeah. The sole argument for the exemption was the president's duties as a chief magistrate demand his whole time for national objects, but Marshall's assessment, those duties were not unremitting, and any conflict could be addressed by the court upon return of subpoena. So it's like, yeah, if there's a problem in like the actual terms of the criminal process, then we can deal with that later. But the subpoena, that's fine. What do it means beyond that, we don't know. But the subpoena, that's fine. Those duties were not unremitting, and any conflict could be addressed by the court return. Marshall also concluded the Sixth Amendment guarantee extended to the production of papers. The propriety of introducing a papers, he explained, would depend on the character of the paper, not the character of the person who holds it. Right, because they're not official records. He might be the president, but they're not presidential records. They're personal records. So it depends on the character of the paper, not who happens to have it, right? Jefferson agreed to furnish whatever justice required, subject to the prerogative to decide whether particular executive communication should be withheld. Yeah, if they're presidential records, then fair enough. In the 2 centuries since this case, successive presidents from Monroe to Clinton have accepted the ruling the chief executive is subject to subpoena, have ultimately agreed to be testified when criminal process, although Clinton, of course, famously fought that in the courts, but ultimately, of course, he did give testimony, which we all know about, right? Anyways, in 1974, the question of whether to compel the disclosure of the official communications over the objection came to a head when the Weathergate special prosecutor secured a subpoena ducis tecum, directing Nixon, among other things, to provide a tape recording, which would be official records, right? It makes it even more interesting issue because that would be a recording that happened in the Oval Office. So those are presidential papers, so it's a more interesting issue. The Court rejected Nixon's claim for an absolute privilege of constitutionality for all the communications. Recognizing compulsory process was imperative for both the prosecution and defense, the court held the president's generalized assertion of privilege must yield to a demonstrated specific need for evidence in a pending criminal trial. And Nixon dutifully released the tape, minus the missing minutes and all that good stuff, but whatever. This history includes These histories all involved federal criminal proceedings, so we could split this on a state versus federal guideline, right? So we could do that, especially on a supremacy clause issue. So these were all federal things, so we could split the baby on that, but we're not going to do that. Here, the president claims the supremacy clause gives a sitting president absolute immunity from a state criminal subpoena because of compliance with the subpoena would categorically impair the function of his role. The Solicitor General, arguing on behalf of the United States, argues that a state grand jury for sitting of the records must at a very least meet a heightened standard of need. So maybe it's not absolute, but maybe we need more than we would for some other person, which is not like wholly unreasonable. In terms of like maybe we need something a little bit more than it would be for your average ordinary person because of the special role. But no, we're not going to do that either. The president's unique duties as head of the executive branch come with protections that safeguard his ability to perform his vital role. The Constitution guarantees the entire independence of general government from any control by their respective states. So the federal government cannot be controlled by state law, right? Marshall ruled Burr entrenched by 200 years of practice, and this court's decision in Nixon confirms that federal criminal subpoenas do not rise to the level of constitutional impairment of the executive's ability to perform its constitutional mandated functions. But the president claims that state criminal proceedings necessarily pose a unique threat of impairment and thus require an absolute immunity. His categorical approaches does three burdens: diversion, stigma, and harassment. The president contends that complying with the subpoenas would necessarily divert the chief executive from the duties. His grounds his concern on the same as Nixon, which recognized a president's absolute immunity from dangerous liability predicated on official acts. These aren't official acts, so that language isn't going to be of any help. But contrary to the president's suggestion, this case did not hold distraction was sufficient to confer an absolute immunity. Instead, the court expressly rejected immunity based on distraction alone 15 years later in the Bill Clinton case that I alluded to earlier, where he fought his subpoena and lost, which also was a state-level process, incidentally. But it was civil, not criminal. So maybe there's a distinction there, right? So it was state level, but it was civil in the case of Clinton versus Jones. But now we're in criminal process. So maybe that's different, but no, it's not. When President Clinton sought absolute immunity from a civil liability for his private acts, as the court explained in that case, dominant concern was not merely a distraction, but distortion of the executive's decision-making process. The prospect that the president may become preoccupied by pending legislation did not ordinarily implicate a constitutional concern. 2 centuries of experience likewise confirm that properly tailored criminal subpoena will not normally hamper the performance of the president. The president claims his case is different. Good luck with that plan. He believes he's under investigation, argues the toll will necessarily be heavier in that circumstance. But the president is not seeking immunity from diversion occasioned by the prospect of future criminal liability. He concedes he may be investigated while in office. His objection is instead to additional distraction caused by a subpoena. Well, the subpoena isn't even to him. Is to his accounting firm. So how distracted can you be, right? That argument runs against 200 years of precedent establishing the president's and their official communications are subject to judicial process, even when the president's under investigation. The president next claimed the stigma of being subpoenaed will undermine his leadership at home being abroad. Well, if that was true, it would have been true in Clinton. We all know how well that worked out. But even if tarnished reputation were a cognizable impairment, no, not so much, because you're the president in particular. So your reputation is not really one of our chief concerns. There's nothing inherently stigmatizing about a president performing a citizen's normal duty of functioning information relevant to a criminal investigation. Fair. Nor can the risk of association with persons or activities under investigation absolve the president of performing this important public duty. Everyone must obey the court. Everyone must obey the court's process, including the president of the United States. It brings warmness to my heart, I must say. The consequences for the president's public standing will likely increase if he's the one under investigation, but the president concedes that such investigations are permitted under Article 2 in the Supremacy Clause, and receiving a subpoena will not seem to categorically magnify the harm of the reputation. In addition, the grand jury's context long-standing secrecy rules aim to prevent the very stigma he anticipates. Yeah, if anyone thinks these records are staying secret for very long, they're an idiot, but, by the letter of the law, that's right. So, okay, great. Finally, the president argues that subjecting the presidents to state criminal subpoenas will make them easily identifiable targets for harassment. The court rejected a nearly identical argument in the prior case of Clinton. Yeah, so all the Republicans who went to court over Bill Clinton are getting exactly what they deserve. And as far as I'm concerned, it was correct in Clinton and it's correct now. So I'm not I'm not salty. I think that the case in Clinton came out right, and I think that its application now is right. So, I'm not a hypocrite. I'm not picking favorites. I'm reading the law, and I'm like, yep, that was the correct decision in the Clinton case. It's the correct decision now. Oh, you don't like the decision now? Then you shouldn't like the decision on Clinton. We don't do politics in law world. We do law in law world. Equal justice under law, baby. It's a great thing. $100 or 100 Swedish krona from Herbert saying, looking forward to a deeper dive into Tulsa. Thank you. That will probably be on later today, much later in the evening. But we will get to it. And we'll probably read the whole thing, assuming we can, because I don't know how long it was. But we'll at least read the majority opinion, assuming we can do that too. But yeah, we'll get into it. Where were we? Let's see. Harassing state criminal subpoenas could, under certain circumstances, threaten the independence or effectiveness of the executive. So we're leaving ourselves open a door that it's possible. But here, though, against the law already seeks to present the abuse. First, grand juries are prohibited from engaging in arbitrary fishing expeditions or instigating evasions out of malice or intent to harass, and federal courts may intervene in state processes that are motivated by bad or conducted in bad faith. Second, because the Supremacy Clause prohibits state judges and prosecutors from interfering with the president's duties, any effort to manipulate a president's policy decisions or retaliate a president through the issuance of subpoena would be unconstitutional attempt to interfere. A state grand jury is seeking blah, 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 blah. Roberts issues the opinion, and Gorsuch and Thomas file dissents. Great. That's fun. So that was easy. And we also have the decision in the companion case for the Congress seeking their records. So I would assume same exact analysis essentially. I wouldn't expect a different vote. I'd expect the same outcome. So we just established can the New York State district attorney, can the guy working for the state in the district of Manhattan in New York County, can he get the records? If the answer for him is yes, the answer for Congress is obviously yes. I mean, come on, right? So, all right, let's find out, can Congress get the records? Here we go. The answer is yes, I'm pretty sure. In April of 2019, 3 committees of the U.S. House of Representatives issued 4 subpoenas seeking information about finances of President Donald Trump, his children, and affiliated businesses. The House Committee on Financial Services issued a subpoena to Deutsche Bank seeking any documents related to any account activity, due diligence, foreign transaction, business statements, debt schedules, statements of net worth, tax returns, and suspicious activity identified by Deutsche Bank, whatever. Is issued a second subpoena to Capital One for similar information. The Permanent Select Committee on Intelligence issued a subpoena to Deutsche Bank that mirrored the subpoena issued by Financial Services, and the House Committee on Oversight and Reform issued a subpoena to the President's personal accounting firm, Mara's USA, demanding information related to the President and several businesses. Although each of the committees sought overlapping sets of documents, each supplied different justification for the request, explaining the information would help guide legislative reform in areas ranging from money laundering and terrorism to financial involvement in U.S. elections. No problem. Petitioners and the president in his person capacity, along with his children and his affiliate business, contest the subpoena issued by the Oversight Committee and the subpoenas issued by the Financial Services and Intelligence Committee. In both cases, petitioners contend that subpoenas lack a legitimate legislative purpose and violate the separation of powers. The president, however, did not argue that any of the requested records were protected by executive privilege, because of course they're not, because they can't, because they're not presidential records. In Maras, the district court granted judgment for the House and D.C. Circuit, finding the subpoena issued by the Oversight Committee served a valid legislative purpose because the requested information was relevant to reforming financial disclosure requirements for the president and presidential candidates. In Deutsche Bank, the district court denied a preliminary injunction, and Second Circuit affirmed in substantial part, holding that Intelligence Committee properly issued a subpoena to the bank as part of an investigation into allied foreign influence into the political processes, which would inform legislation to strengthen national security and combat foreign meddling. The court also concluded the subpoenas issued by the banks were adequately related to potential legislation. Yeah. Ooh, maybe there's a different outcome here. Ooh, maybe I was really wrong. Ooh, maybe I was all the wrong. The court below did not adequately take account of significant separation of powers concern implicated by the congressional subpoenas for the president's information. Ooh, so maybe I was very wrong. Wow. Okay, so, all right. Wow. All right, if I'm about to be very, very wrong, then so be it. But wow, let's find out. Historically, disputes over congressional demands for presidential... It sounds, although, like they're punting rather than issuing a decision one way or another. So it sounds like they're punting with instructions. So we'll see how wrong I am, I guess, in a second. But I'm still I'm still a little wrong because I assumed it would be a slam dunk, and it's not. So even if they punted, I'd still be a little wrong. Historically, disputes over congressional demands for presidential documents have been resolved by political branches through negotiation compromise without involving the court. The court recognizes the dispute is of the first kind to reach the court, that disputes can raise serious issues concerning relations between the branches, and similar disputes recur on a regular basis, including the context of deeply partisan controversies, and Congress and the executive have nonetheless managed for 2 centuries to resolve these disputes among themselves without our guidance. So are we saying this is a political question? That'd be fun. Such long-standing process is consideration of great weight in cases concerning the allocation of power between the 2 elected branches of government, and imposes on the court a duty of care to ensure that it does not needlessly disturb the compromises and working arrangements reached by the branches. Each House of Congress has power to secure information needed in order to legislate. The power is indispensable because without it, Congress would be unable to legislate. Because the power is justified solely as an adjunct to legislative power, it is subject to several limitations. Most importantly, the subpoena is valid only if it's related to and furtherance of a legitimate task of Congress, which I think the Supreme Court has said like once, maybe twice. It wasn't true, so I wouldn't think it would be true now, but okay. The subpoena must serve a valid legislative purpose. Further, Congress may not issue a subpoena for the purpose of law enforcement because this power is issued to the executive and the judiciary. Finally, recipients of Congress subpoena retain their constitutional rights through various privileges throughout the course of investigation. The President contends, as does the Solicitor General on his behalf, that congressional subpoenas for the President's information should be evaluated under standards set forth in United States versus Nixon and the Senate Select Committee on the Presidential Activities versus Nixon, which would require the House to show the requested information satisfies a demonstrable specific need and is demonstrably critical to this legislative purpose. Nixon and the Senate Select Committee, however, involve subpoenas for communications between the President and his close advisors over which the President asserts executive privilege. In other words, presidential papers. So when we're looking at personal papers, that's definitely not the right analysis, it would seem to me. That protection should not be transplanted root and branch to cases involving non-privileged private information, right? Official records and non-official records should be viewed very differently. No problem with that. The standards proposed by the President and Solicitor General, if adopted outside this context, would risk seriously impeding Congress in carrying out its responsibility, giving short shift to its important interests in conducting inquiries to obtain information. Okay, I am going to give a new revised prediction. I am giving a new revised prediction that the Supreme Court is actually really saying that yes, Congress can get the records, but they are specifically doing it in a very particular way to punt this back down on the idea that it will not happen until after the election. So I am revising my prediction that the real answer to this question is yes, Congress can get the records, but not right now. So they've created for themselves an excuse to delay this long enough to try to get it past the election. So I'd still be wrong, but I wouldn't be quite as wrong. So I said yes, unambiguously, and the answer would be yes, but not now. So we will find out if my new revised prediction is correct. Let's find out. The approach proposed by the House, which relies on precedents that did not involve the President's papers, fails to adequately account on the separation of powers issue raised by Congress's subpoena. The House approach would essentially leave no limits on this power to subpoena the President's personal records. A limitless subpoena power could transform the established practice of political branches and allow Congress to aggrandize itself at the President's expense. These separation of powers concerns are unmistakably implicated by subpoenas here, which represent not run-of-the-mill legislative effort, but rather a clash between rival branches of government over intense political interests. The intra-branch conflict does not vanish simply because the subpoena seek to personal papers or because the President is sued in his personal capacity. Nor are separation of powers concerns less palpable because the subpoenas were issued to third parties. Yeah. I feel like the answer is yes, but not now. We'll find out, though. Neither side identifies an approach that would adequately account for these weighty separation of powers concerned. A balanced approach is necessary, one that takes considerable impression from the practice of government and resists the pressure inherent on each branch with separate powers to go outside their power. In assessing whether the subpoena directed at the President's information is related to and furtherance of a legislative interest, the courts must take adequate accounts of separation of powers at stake, including both significant legislative interests and the unique position of the President. Several special considerations inform this analysis. First, the courts should carefully assess whether the set of legislative purpose warrants a significant step of involving the president and his papers. Occasions for constitutional confrontation between the two branches should be avoided wherever possible. Congress may not rely on the president's information if other sources could reasonably provide Congress the information. For example, hence, maybe you can get them from the district attorney of New York, right? Maybe you could get them from the district attorney of New York. Hence. So Congress cannot do it if other sources, which, that we just issued another opinion that might give you another source. Maybe look at that, right? All right, so second, to narrow the scope of the potential conflicts between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. The specificity of a subpoena's request to serve as an important safeguard against unnecessary intrusion into the operations of the office of president. Third, the courts should be attentive to the nature of the evidence offered by Congress to ensure the subpoenas advance a legislative purpose. The more detailed and substantial, the better. How does any of this apply to Trump's kids, I wonder, but whatever. That's particularly true when Congress contemplates legislation that raises sensitive constitutional issues, such as legislation concerning the president. Fourth, courts should assess burdens imposed by the president by the subpoena, particularly because they stem from a rival political branch that's an ongoing relationship with the president and incentives to use subpoenas for institutional advantage. Other considerations may be pertinent. One case every 2 centuries does not afford enough for an exhaustive list. Roberts delivers the port in which Ginsburg, Breyer, Sotomayor, Kagan, and Kavanaugh join, and Thomas and Alito dissent. Ooh, okay. So that's an amazing result. That's an amazing result. Trying to figure out exactly what's going on a 7-2 decision. So we are definitely going to have to get into that, into reading the opinion. And we've read the syllabus, but we're going to definitely have to read the opinion and try to read much more between the lines of what's going on. So I will mark myself as wrong for the purposes of today's exercise. Because what I said was, oh, this is going to be unambiguous, slam dunk, yes, no problem, and whatever else this is, it is none of those things. So I have to mark myself off. So I'm going to give myself 1 for 2 today. So I was right on the Oklahoma thing, and I was wrong. Well, actually, technically, I'm 2 for 3 because I was right on the Vance thing. I thought they would come out the same, so I thought they'd join together. So I was 2 for 3. So I was right on the district attorney and I was wrong on Congress, which is really, really weird because if you had asked me in advance, I would have said it would have been the other way around. So if you had asked me like to put a hedge on my bets, I would have hedged the other way, right? I would have said, oh, yes to Congress and wrong to the, and not to the district attorney. Separation, sovereignty of the executive and separation, federalism and supremacy clause and blah, blah, blah. So if you'd asked me to hedge my bets, I would hedge the other way. So I am surprised in the outcome, and I'm surprised that the split was the way it was. So, okay. But I don't know how wrong I am because the syllabus didn't really tell me how wrong I am. It sounds suspiciously like I'm reading between the lines. So we all have to read between the lines together and try to figure out what are they really saying. And it sounds suspiciously to me like what they're saying is, please just go and perfect this record. I know you did a good job, but would you please waste about 4 months exactly on this issue? Could you do that for me? Could you waste exactly 4 months for me and issue the subpoena then? That'd be great. It sounds suspiciously like what that is really saying, if I'm reading between the lines. So I think the answer is yes, but not today. It's like, we just want you to make sure that you're taking this really super seriously. We just really want you to really carefully look at it for about 4 months. Could you do that for us? That'd be wonderful. So I think the answer is yes, but not today. And also, like, you can get it from the district attorney, maybe, possibly. But yeah, I wouldn't. So we'll see. But I'm also surprised that was this because the select committees were also going after his children. So, like, I'm very surprised that they didn't split the difference on his children and stuff, because whatever else those children might be, they're not the president of the United States. Now, some of them work in the Oval Office. Maybe they all do. So that'd be an interesting turn of events. If, like, the fact they work inside the Oval Office is what is giving them this cover, or at least the Supreme Court giving them an excuse to do this. But it sounds a little bit like yes, but not today. So I think that's what's going on. I think that's what's going on. But I was wrong. I was wrong. So 2 for 3, 2 for 3. You know, I was wrong. I thought that this would be a slam dunk, no problem. There's an explicit statute that says this. Congress has a valid legislative purpose. They've like said once, maybe twice in the last 100 years they don't have one. No problem. And I guess I didn't sufficiently consider the separation of powers concerns. And the fact this is a 7-2 decision is also leading me to the conclusion that the answer is yes, but not now. So I thought that 7-2 said, oh, I'm unambiguously right. So I was wrong. And whether or not I'm correct about my new revised prediction, I don't know. But we're going to have to read it with way more detail. We have to read it with way more detail and read between the lines to figure out whether or not my new revised prediction is correct. Whether or not the answer is really yes, but not now. So I don't know. Yeah, I'm reading. Yeah, so I'll answer a couple questions, and I just saw one right now. It says, "How does the Supreme Court know that four months is long enough to avoid an October surprise?" Well, the courts of appeal can only move so fast, and even if you know, even if the Court of Appeals, like the fastest they could, like say they do this in a month, which would be like amazing to be able to do that, right? To actually be able to do all that, because you have to go back, you have to give each side an attempt to brief, right? So both sides get an attempt to brief. Again, because there's been a revised law, there's got to be oral arguments. They've got to consider it, they've got to issue it, they've got to really go through all that detail. That's going to take time. So say they do all that inside a month, which seems impossible, but say they do. All right, great. Then what happens next? Well, Trump loses at the Court of Appeals, because of course he does. And then the next thing that happens is they appeal to the U.S. Supreme Court. And then the U.S. Supreme Court probably issues a stay while and they issues a stay, and then they decide, no, we're not going to do it after all. And they issue that decision, just after the election. So, I mean, the Supreme Court can freeze this ball until after the election if they want. No problem. We are going to issue a stay pending resolution of our consideration, and we decide not to. And what do you know? It's November the 15th. What are the odds? So that seems to be exactly where this is going. Supreme Court can keep this. Supreme Court can freeze this until after the election if that's what they're trying to do. Yeah, so that's exactly what's going on. Yeah, I think so. I'll just go back and try to respond to some of the comments. And again, I apologize for any distraction, because I have a voice in my ear trying to listen to something at the same time, which is going super well, by the way. Yeah, good morning. Tulsa's not in Oklahoma. We're definitely going to have to read that a lot more carefully. So that's going to be a much bigger thing at some point. That'll probably be a live stream. So we have to do at least 2 live streams. We have to do one on Oklahoma. That's going to take a while. And then we're going to do this one. That's going to take a while. So I don't think we can do those both today, because I don't think I have that kind of energy. We might try. We'll see how much live stream energy I have, whether or not I can get two new live streams in, because they're both going to be like 2 hours probably, because we're going to have to really read it, really consider it, really read between the lines on both of them, for that matter. In the Oklahoma thing, I have said that what the implication is that all those criminal cases are void, but I don't actually know that. I don't know that for sure. I actually have to read it and see whether or not, and I don't know the implications for other things beyond that. So we have to read those way more carefully. I mean, I got the right result, but we don't know the full implications of it, is what I mean, right? So we'll see. Yeah, I'm confused. Well, the immediate implications of the Oklahoma case is that these 2 cases, the McGurk and the other one, that their criminal convictions are void. So the guy who got the death penalty and the guy who got the 1,000 years in prison, they are going to be freed, like immediately. Their cases are void. Now they can be arrested immediately by the feds, and they probably will be, I would imagine. The U.S. attorney isn't no fool, and because the U.S. attorney and there's no statute of limitations on murder, so they'll be arrested immediately, and maybe immediately rearrested by the FBI, because that's what I'd do if I were the U.S. attorney, right? But So their freedom from prison will last about 5 seconds, but they will have to be tried again, and they're going to go criminal, and they might get not guilty the second time around. But their immediate implication is, well, their state prison time is at an end, presumably like immediately. So that's what's happening there. Grand juries may be pointless, but they're constitutionally required in the case of the federal government, and they have purposes in the state government too. So, yeah, yeah. Deutsche, that's right, Deutsche Bank. I knew that. I just couldn't quite remember because again, I had a voice in my head. Deutsche Bank. I did know that. Thank you. This just appeared in your recommended. Well, I'm glad it did, Connor. I hope you're enjoying this legal stream. I hope you're still with us. We do legal analysis, legal discussion. That's what our channel's all about. So I hope that you enjoy legal discussion, legal analysis, and we're doing awesome law done quick today. We did 3 Supreme Court decisions in 40 minutes. Not too bad, right? Mm. Yeah, Congress needs an excuse, and Congress does have an excuse. Congress's excuse is just fine, to be quite honest. I'm pretty sure. It's just like we really want you to consider that excuse more carefully. We just want you know we know you considered it. Could you take another look? Could you consider it a little bit? Could you look at it a little bit closer, for preferably for about 4 months? That'd be great. Trump has to give his tax returns to the district attorney in Manhattan. He does have to give his tax returns to them, or whatever else is in these banks' possession to be more proper. But not to. Yeah, it's a weird result. Federalism isn't enough to shield you, but separation of powers is. Okay, well, that's why we do these things. We all learn more law together. We all become smarter every day. I'm cheating. I'm borrowing Dusty's thing. Yeah, smarter every day. Does that mean they can put casinos in Tulsa? I have no idea, man. That's why I was saying I don't know. I don't know what the implications of this are. I know what the immediate implications are. These two guys are going to be freed from state jail, immediately arrested by the FBI, put in federal jail, and retried. But as to the broader implications of what does it mean for all the other criminal convictions? What does it mean for casinos? What does it mean for tribes' ability to regulate and so forth and so on? Don't know. I don't know. What does it mean for the impact on the city government, if any? What does it mean for the state government, if any? I don't know. I don't know what the implications are of this beyond the criminal convictions. So I don't know. We're going to get into it and get in there. You missed most of the stream. Darkmen 42. Can you get a recap? Yes, you can. Half of Oklahoma is now Indian territory. 2 people who are convicted on state court are now not convicted. They will have to be retried in federal court. No problem, though, because statute of limitations has not expired. Trump does have to give his tax returns to the district attorney in Manhattan, and he does not have to give his tax returns into Congress now. Maybe later, but not today. Maybe 4 months from now, but not today. So, yeah, there's your recap. I know I have something in my ear. I'm listening to something else at the exact same time I'm talking to you, which is making things very entertaining. Please move Tulsa off our land. I don't. Well, that's the thing though, too, because it's not their land. Because they gave away all the land in apportionment. That's one of the funny things about it, right? So they don't have any land, and I forget if they abolished the tribal leaders altogether or if they just removed all their power. I think the latter. I think the tribal leaders are technically a thing that still exists. They just have no power to do anything, but they still exist. So yeah, I don't know. This may have no implications. This may have no implications beyond the criminal convictions. If I had to guess off the top of my head, it might have no implications because, as I remember, they removed all the tribal power to do stuff, and so they would have the ability to do things. So it just has criminal implications. So there's that. I know Congress is delayed, but how fast would the state court need to get it? Presumably, I mean, as soon as this is final, they're going to issue a request for reconsideration, which will be denied. So I would presume 2 weeks, something in that time frame. The state court will get it, and then the grand jury will somehow leak, even though grand juries like never leak. You know, so that'll be a thing. I don't think the tax records are going to reveal anything that's going to be majorly shocking. I don't think that they're going. I don't think there's a red herring anywhere in there. At best it might be embarrassing that he missed out on a deal or something, but I don't think there's any red. I don't think there's any red herring or bombshells. I think the odds of Trump's tax returns becoming public information before the election are pretty freaking high. Let me put it that way. Yeah. So I guess I will. Uh, FISA court is one of the secret courts. What other secret courts are there? Well, technically speaking, although this is maybe a distinction without a difference in your mind, the FISA court is not a secret court. Its decisions are secret, which is different. Like the fact that FISA exists is not secret. It's just that its decisions are secret. So, yeah, but they're to my knowledge. Well, if there were secret courts, I would know about them, but there aren't any that I'm aware of. So, uh, there there are no secret agencies or no secret courts, obviously, that I would know about. So, probably none. I think the Supreme Court punted because they knew it become moot because of the New York case. I don't know if it's totally moot because I think the differences in subpoenas are different, and the Congress did want other things other than the president's records, which again is a bit surprising that they couldn't get all that stuff because separation of powers wouldn't presumably apply to his children's assets, but apparently it does for some reason. But it's just like, can you go forward and prove that in more detail? Yeah, so we'll see. Okay, well, I'm going to go ahead and end the stream because there's no new law to be decided right now, and we definitely are going to have to schedule more streams later, so I don't know when that will occur. But we will definitely do streams on Oklahoma in depth. We'll do streams on the tax thing in depth, but we will do that later, and we'll get there. So for the 119 of you, excuse me, for the 119 of you who are currently watching, for the 119 of you who are currently watching, thank you very much for being here. If you enjoyed this stream, if you'd be so kind as to give it a like before you leave, I'd appreciate it. It helps with the YouTube algorithm and metrics and all that good stuff. If you enjoyed this content or if you found it educational or informative in any way, that'd be super helpful. For those of you who really liked this content, somewhere on your screen near where the subscribe button is or should be, there should be a join button. If you press that button, for 99 cents a month, you can get your name in green. You can be a member of the channel, and I will like you more. So if you'd be so kind as to join, I'd appreciate it. So until later, my friends, I hope all is well. Cheers and goodbye.